Part 4 of Public Corruption in Defiance, Ohio. My mom had contacted my attorney who filed the lawsuit, Mr. Arnold, and he got a hold of Defiance. You see, he was my attorney on record. The city and the county all knew who he was. They had his address. And by law, when you have an attorney on record, they have to issue the stuff to him if they do not know where you're at or cannot find you. That way he can get a hold of me and we can take care of it that way. Surprise, surprise, Defiance broke the law yet again. They didn't do that. They sent it to an address where they knew I would not get it, so that they could get me and arrest me yet again. By the time I was released from the hospital, the warrant had expired. Expired in 2 weeks' time? I've never heard of a warrant doing that. But they released me. I got to go home. After that, my attorney contacted me and told me that the federal court had ruled in my favor. They answered Defiance's, yeah, it's our fault, but. Let me read you exactly, word for word, this is just one paragraph of what the judge said, Judge Carr from the federal court. Cron's pleads facts are far more egregious than those in a slip-and-fall case. A rational jury could find that the risk posed by the shackles and too long a pants was so obvious that the supervising officials must have been aware that Cron could fall. Closing one's eyes and doing nothing in the face of such manifest risk, a rational jury could find constitutes a deliberate indifference to the inmate's safety and well-being. A prisoner's walking impairment, whether caused by injury or excessively long pants and shackled legs, is much more obvious, particularly to the individual leading the prisoner down the stairs. Moreover, the facts in this case are more egregious than even those in Wilson and St. Clair, or St. period. Here, officials actually created the inmate's impairment to walking by requiring her to wear the pants and the shackles and walk up and down steps. I think the judge used the word egregious about 3 times in there. He didn't sound very happy with it. Well, Defiance was really unhappy about that ruling. Then you know what they did? They filed arson charges against me. They went before a grand jury, fabricated evidence, lied to the grand jury, got an indictment, and issued a warrant for my arrest for 4 counts of aggravated arson, which could put me in jail up to 48 years. It's kind of funny. Mr. Murray, Morris Murray, the prosecutor of Defiance County, did an interview the day after I was, well, I guess he did it the day before I was arrested. He put out there that he didn't know where to find me, but knew for sure, or let me read it to you, it'll be better that way. Morris Murray said in an interview on June 18th of 2009, said the indictment came 3 years after the fire because multiple investigating agencies were involved and personnel changes had occurred within them. Well, I personally have seen state's witness lists, which Mr. Murray had to provide to my attorney during discovery. And the people that I talked to 3.5 years ago when the fire happened are the same people he says he will subpoena. So if there was all these different investigating agencies and so many different personnel, why aren't they on the list for being subpoenaed? He also says in the same article that Jackie is still at large and that he does not know where to find me. But the funny thing is, he says he did not know where to find me, but he sure knew where to send the cops to arrest me. He's lying again. Well, the night before this article came out in the Crescent News, the same day that the indictment came down, the Oakwood Town Cop and the Paulding County Sheriffs were all in Oakwood that night. The Oakwood town cop, chief of police, he was a very nice man, came in, talked to me for a little bit, and he says, Jackie, he says, I hate to do this. There's a warrant issued for your arrest. Again. I couldn't believe it. The fact that Defiance is allowed to abuse that power like this is just wrong. Beyond wrong. The town cop came in and he said that there was a warrant out for me. I said, what for? What now? What more do they want to do? And he said, it's for arson. It's serious. 4 counts of aggravated arson. I was stunned. I couldn't believe it. How? Why? All these things running through my head. Well, Oakwood would not arrest me and take me into custody. Paulding County Sheriff's Department wouldn't. They knew about the lawsuit. They were aware of it. They knew these charges were bogus. They knew it was just Defiance trying to hurt me again. And they refused to have any part of it other than to stay there at the house and wait for the... They called the Defiance County Sheriff and said to him that he had to come down to the house personally and arrest me because they would not. Well, during that time I had a breakdown, I guess. I just remember thinking, I'm tired of fighting him, tired of being him, tired of being in this world. And I just wished I could go back to being a kid. Well, that's about the last thing I remember. My son Zachary said I started scratching my stomach. I've still got the scars on my stomach. I was trying to dig a hole through my stomach. And they said that I kept saying that I was going home or I wanted to go home. Over and over that's the only thing I would say. So they called the rescue squad, they loaded me up, they took me to Defiance Regional Medical Center, where Dr. Moeller, wonderful doctor that he is, his co-workers call him Bipolar Moeller. Well, he doped me up. Instead of doing something for me, he doped me up with a bunch of medicine. I don't know how long I was there, but after a while, after the medication was in me for a while, I started to come back around. My mom was there by then. And she told him, you've got to stop them from taking her to CCNO. They will kill her. They will not give her her medication. They won't do anything for her. Well, I have anaphylactic reactions to medicine, so Dr. Moeller gave me a shot to prevent me from, if I did have a reaction to the medicine, at least I wouldn't stop breathing and keel over and die. So he called CCNO. He talked to him. He told him what kind of medicine I had, when I had to have it. He told him he was sending my medication with me out there, and that they had to give it to me every day, morning and night. I could not miss it because if I did, I could die. Oh, they assured him that they would give me my medicine, they'd take good care of me, not a problem, they'd put me in the medical unit. Well, they took me out there, got me out there, locked me in a medical cell, left me there the whole night, no heart medicine, no sugar medicine, no nothing to help me. Next morning, they come, they get me out, they take me to see the doctor. He says, well, we'll change this medicine, take you off that medicine, add this one, change this one to that one. He didn't even know my medical history. I hadn't even talked to him 5 minutes, and he's making the decisions that I don't need this medicine or that medicine, and we'll change this medicine to that. How does he have the right when he doesn't even know my medical history? Well, then he goes and sends me out, puts me in the regular, population with the rest of the prisoners. Guess what? Still no medicine. Nothing at all.